A pleasant day to everyone who is watching this presentation. We are Group 2 and today we are going to present the case study number 2, Initiation in Resort, Dandy A. Aidungo and Gregorio A. Cibal Jr. versus People of the Philippines.
Now, let's move to the fact of the case. On February 1, 2006, the Office of the City Prosecutor of Calamba, Laguna filed the information against the petitioners before the RTC. The accusatory portion of which reads, a new member of Alpha Pi Omega Fraternity, Marlon Villanueva, that died during the initiation rite with an unidentified more or less 20 members and officers including Dante L. Dungo and Gregorio A. Cibal, who are the accused responsible for Villanueva's death on or about 2:30 a.m. January 14, 2006 at Villanueva, Barangay Pansol, Calamba City, Province of Laguna. The said initiation rite is for him to admit in to the fraternity, but unknowingly it will cause him physical damages resulting to his death.
Around 3:20 a.m. January 14, 2006, the victim, Marlon Villanueva, was brought to the emergency room of Dr. Jose P. Rizal District Hospital. Dr. Ramon Masilungan, physician at the emergency room, observed that Villanueva was motionless and not breathing and had no heartbeat, so tried to revive Villanueva for about 15 to 30 minutes. Villanueva did not respond and was pronounced dead. Dr. Masilungan noticed a big contusion with a hematoma on the left side of the victim's face and several injuries on his arms and legs. He attested that the blood in Villanueva's face was no longer running through his body due to lack of oxygen, and when he pulled down his pants, he saw large contusions of both legs which extended from the upper portions of the thighs down the coplaxial portion of the back knees.
The prosecution presented 20 witnesses to prove the crime charge. First, Dr. Magsilungan disclosed that two men brought Villanueva to the hospital. The two told him that they found Villanueva lying motionless on the ground at a store in Barangay Pansol, Calamba City, and brought him to the hospital. When he asked them where they came from, one of them answered that they came from Los Baños, Laguna, en route to San Pablo City. He questioned them on how they found Villanueva when the latter was in Barangay Pansol, Calamba City. One of the men just said that they were headed somewhere else. Dr. Magsilungan reduced his findings in a medical legal report. Due to the nature, extent, and location of the injuries, he opined that Villanueva was a victim of hazing. He was familiar with hazing injuries because he had undergone hazing himself when he was a student, and also because of his experiences in treating victims of hazing incidents.
Dr. Roy Carmelito, a medical legal officer of the Philippine National Police Crime Laboratory in Region 4, performed an autopsy on the body of Villanueva. He opined that the injuries was hazing related.
The third witness was Susan Ignacio. She was the owner of the sari-sari store located at Purok 5, Pansol, Calamba City, in front of Villanueva Resort, which was barely 10 steps away. On January 13, 2006, at around 8:30 to 9 o'clock in the evening, she was tending her store and she saw a jeepney with more than 20 persons arrive at the resort. Ignacio identified Dungo as the person seated beside the driver of the jeepney. She estimated that ages of this person in the group to be between 20 to 30 years old. They were in civilian clothes, while other men wore white long-sleeve shirts. Before entering the resort, the men and women shook hands and embraced each other. Three persons riding a single motorcycle also arrived at the resort. Ignacio saw about 15 persons gathered on top of the terrace of the resort who looked like they were praying, and then the lights of the resort were turned off. Later that evening, at least 3 of these persons went to her store to buy some items. During her testimony, she was shown photographs and she identified Christopher Baraceros and Ciel as two of those who went to her store. It was only on the morning of January 14, 2006 that she learned from the policeman visiting the resort that this person was Villanueva.
Donato Magat, a tricycle driver plying the route of Pansol, Calambas City, testified that a man approached him and told him that someone inside the resort needed a ride. Afterwards, he saw three men in their 20s and 30s carrying another man who looked very weak, like a vegetable. He touched it and it is cold. Then they instructed Magat to go to the nearest hospital.
The next witnesses are Abelardo Natividad and Seferino Espina y Habay. They were the security guards on duty at J. P. Rizal Hospital from 11 o'clock in the evening of January 13, 2006 until 7 o'clock in the morning of January 14, 2006. In the early morning of January 14, 2006, two men who signed on the logbook 13 under the names Brandon Gonzalez and Jericho Paril brought the lifeless body of a person. Pursuant to the standard operating procedure of the hospital, the security guards did not allow the two men to leave the hospital because they called the police station so that the investigation could be conducted. Two policemen arrived later at the hospital. During his testimony, Natividad identified Sibal and Dupgo as the two persons who brought Villanueva to the hospital.
Police officer Alindon Ignacio testified that on January 14, 2006, around 3:30 o'clock in the early morning, Natividad called up the PNP Calambas City Station to report that a lifeless body was brought to J.P. Rizal Hospital. When he arrived, he saw Villanueva's corpse with contusions and bite marks all over his body.
The next witness was Gay Zarina Sunga. She was a food technology student at UP Los Baños during the academic year of 2005 to 2006 and a member of a Symbiosis UPLB Biological Society. Around 2 o'clock in the afternoon of January 13, 2006, she was at their organization's tambayan in the UPLB Biological Sciences building when she was noticed three men seated 2 meters away from her. She identified the two of the three men as Sibal and Dungo. They were wearing black shirts with the logo of Apo. Later at 5 o'clock in the afternoon, two more men arrived and with their heads bowed approached the three men. One of them was Villanueva, who was carrying a 5-gallon water container. Dungo then stood up and asked Villanueva why the latter did not report to him when he was just at their tambayan. Dungo then punched Villanueva twice, but the latter just kept quiet with his head bowed. 15 minutes later, all of the men left.
Joey Atienza, a good friend of Villanueva, said that Villanueva introduced him to Jarrell De Sena as his Apo Theta Chapter 3 batchmate who was also to undergo final initiation rites on January 13, 2006.
Next witness, Severino Cuevas. Director of the Student Affairs of UP Los Baños, testified that Dungo and Sibal were both members of the Apo fraternity and that there was no record of any request for initiation or hazing activity by the said fraternity. MacArthur Padua of the Office of the Registrar UP Los Baños testified that Villanueva was a BS Agricultural Economics student at the UP Los Baños 15 as evidenced by his official transcript of record.
Attorney Hernando Peralta and Dina S. Carlos, officers of the Student Disciplinary Tribunal of UP Los Baños, testified that an administrative disciplinary case was filed on March 31, 2006 against the Apo fraternity regarding to the death of Villanueva.
Next, Roman Miguel de Jesus, UP Office of the Legal Aid Supervising Student, testified that he met Tan of the Apo sorority sometime between July and August 2006 in UP Diliman to convince her to testify in a criminal case. Tan, however, refused because she was feared of her safety. She said that after testifying in the SDT hearing, her place in Imus Cavite was padlocked and vandalized.
Evelyn Villanueva, the mother of the victim, testified that as a result of the death of her son, her family incurred expenses in the aggregate amount of 147,000 pesos.
The defense presented 7 witnesses to prove the innocence of the petitioners. First witness, Richard Cornelio. An Apo fraternity member testified that on January 13, 2006, around 4 to 4:30 o'clock in the afternoon, he met Dongo at the UP Los Baños Graduate School. Dongo asked him if he would attend the initiation ceremony, and Cornelio answered that in the negative because he had other things to do. At 10 o'clock in the evening at the same day, Cornelio again met Dungo and his girlfriend while eating a hamburger at the burger machine along Raimundo Street, Umali Subdivision, Los Baños, Laguna. He asked Dungo if he would attend the initiation ceremony. Dungo replied that he would not because he and his girlfriend has something to do.
Ana Danife Rivera, the girlfriend of Dungo, testified that on January 13, 2006 at around 1 o'clock in the afternoon, Dungo came and visited her at her boarding house in Raimundo Street. Around 4 o'clock in the same afternoon, they went to the UP Los Baños Graduate School and saw Cornelio. Here are the ruling made by the court. The evidence of the prosecutors undeniably proved that Villanueva, a UP Los Baños student, was a newbie at the Apo Theta Chapter fraternity, that Dungo and Sibal were members of the said fraternity, that on the evening of January 13, 2006, Dungo and Sibal, together with other fraternity members, officers, and alumni, brought and transport of Villanueva and two other newbie to Villanueva Resort at Barangay Pansol, Calamba City for the final initiation rites. The RTC explained that even if there was no evidence that Dungo and Sibal participated to bodily assault and harm the victim, it was refutable that they brought Villanueva to the resort for their final initiation rites. Clearly, they did not merely persuade Villanueva to attend the final initiation, but they also brought him to Villanueva Resort.
The critical portion of the decision reads that the court finds the accused Dante Dongo and Gregorio Sibal guilty of violating Section 4 of the anti-hazing law and sentenced them to suffer the penalty of reclusion perpetua in order them to jointly and severally pay the family or heirs of the deceased Marlon Villanueva the following sums of money for actual damages, moral damages, exemplary damages, and for his debt with a total of 491,324,000 pesos. So ordered that the petitioners filed a notice of appeal. In their brief, they contended that the prosecution failed to establish their guilt beyond reasonable doubt for violating RA number 8049. They also assailed that constitutionality of Section 4 of the said law, which stated that mere presence in the hazing was prima facie evidence of participation therein, because it allegedly violated the constitutional presumption of innocence of the accused.
According to the CAA ruling, they discussed that the unbroken chain of circumstantial evidence to convict Dungo and Sibal as principals in the crime of hazing. Both the RTC and the CA found them guilty of violation Republic Act number 8049 because they induced the victim to be present during the initiation rites. The crime hazing by the inducent does not necessarily include the criminal charge of hazing but by actual participation.
This positive portion of the decision reads that premises considered the February 23, 2011 decision of the Regional Trial Court, Branch 36 of Calamba City in criminal case number 13958-2006 finding accused appellant guilty beyond reasonable doubt of violation of RA 8094 is hereby affirmed in tutu. United States laws and jurisprudence on hazing. There are different definitions of hazing depending on the laws of the states. In the case of People v. Lenti, the defendant therein challenged the constitutionality of the state law defending hazing on the ground of vagueness. Presently, the acceptable definition of hazing is the practice of physically and emotionally abusing newcomers to an organization as a means of initiation. Hazing can be classified into various categories including, but not limited to, acts of violence, acts of humiliation, sexual-related acts, and alcohol-related acts. The U.S. anti-hazing laws and jurisprudence show that victims of hazing can properly attain redress before the court. By crafting laws and prosecuting offenders, the state can address the distinct dilemma of hazing.
The anti-hazing law in the Philippines is under the Republic Act No. 8049 or the Anti-Hazing Law of 1995. It has been enacted to regulate hazing and other forms of initiation rites for fraternities, sororities, and organizations. Defines hazing as an initiation rites or practice as prerequisite for admission into membership in fraternity, sorority, and organization by placing the recruit, neophyte, or applicant in some embarrassing or humiliating situations such as forcing him to do menial, silly, foolish, and other similar tasks of activities and otherwise subjecting him to physically or psychologically suffering or injury.
Contrary to law, on the manner of how the information should be worded, Section 9, Rule 110 of the Rules of the Court is enlightening.
Under Section 9, cause of the accusation, the acts or omission complained of as a constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language to enable a person of common understanding to know what offense is being charged as well as its qualifying and aggravating circumstances, and for the court to pronounce judgment. The court agrees with the OCG that the planned initiation rites as stated in the information included the act of inducing Villanueva to attend it. In ordinary parlance, a planned event can be understood to have different phases. Likewise, the hazing activity had different stages and preparators had different roles therein, not solely inflicting physical injury to the neophyte.
Conspiracy of the offenders was duly proven. A conspiracy exists when two or more persons come to an agreement concerning the commission of the felony and decide to commit. To determine the conspiracy, there must be a common design to commit a felony. To avert or acts of the accused may consist of active participation in the actual commission of the crime itself, or may consist of moral assistance to his co-conspirators by moving them to execute or implement the criminal plan. And according to them, it need not to be shown that the parties actually came together or agreed in express terms to enter into and pursue a common design. Responsibility of a conspirator is not confined to the accomplish of a particular purpose of conspiracy, but extends to collateral acts and offenses incident to and growing out of the purpose intended. RA number 8049, Section 4, Paragraph 6 thereof provides that the presence of any person during the hazing is prima facie evidence of participation as principal unless it prevented the commission of the punishable acts. The testimony of Ignacio was direct and straightforward. Her testimony was given a great weight because she was a disinterested and credible witness. The prosecution indubitably established the presence of Dungo and Sibal during the hazing. Such gave rise to the prima facie evidence for their actual participation in the hazing of Villanueva. They were given an opportunity to rebut and overcome the prima facie evidence of the prosecution by proving that they prevented the commission of the hazing, yet they failed to do so. Because of the uncontroverted prima facie evidence against the petitioners, it was shown that they performed an overt act in the furtherance of the criminal design of hazing. Not only did they induce the victim to attend the hazing activity, the petitioners also actually participated it based on the prima facie evidence. The fact that are sufficient to establish their roles in the conspiracy of hazing. Not only did they induce the victim to attend the hazing activity, the petitioners also actually participated in it based on the prima facie evidence. These facts are sufficient to establish their roles in the conspiracy of hazing. Under RA number 8049, the participation of the offenders in the criminal conspiracy can be proven by the prima fuzzy evidence due their presence during the hazing unless they prevented the commission of the acts therein. The guilt of the petitioners was proven beyond reasonable doubt. In considering a criminal case, it is critical to start with the law's own starting perspective on the status of the accused. In all criminal prosecutions, he is presumed innocent of the charge laid unless the contrary is proven beyond reasonable doubt. The rules on evidence and precedents to sustain the conviction of an accused through circumstantial evidence required the existence of the following requisite. Number 1, there are more one circumstance. Number 2, the inference must be based on proven facts. Number 3, the combination of all circumstances produces a conviction beyond reasonable doubt of the guilt of the accused. To justify a conviction upon circumstantial evidence, the combination of circumstances must be such as to leave no reasonable doubt in the mind as to criminal liability of the accused. Jurisprudence requires that the circumstances must be established to form an unbroken chain of events leading to one reasonable conclusion pointing to the accused and to the exclusion of all others as the author of the crime. The petitioners, Dungo and Zibal, on the other hand, presented the defense of denial and alibi. These defenses, however, must fail. Time and time again, this court has ruled that denial and alibi are the weakest of all defenses because they are easy to conduct and fabricate. The testimonies of the defense witness also lack credibility and reliability. The corroboration of defense witness Rivera was suspect because she was the girlfriend of Dongo, and it was only logical and emotional that she should stand by the man she loved and cared for. The testimonies of their fellow fraternity brothers, likewise, do not hold much weight because they had so much at stake in the outcome of the case. Stated differently, the petitioners did not present credible and disinterested witnesses to substantiate their defenses of denial and alibi. After a careful review of the records and the court agrees with the Court of Appeal and the RTC that the circumstantial evidence presented by the prosecution was overwhelming enough to establish the guilt of the petitioners beyond a reasonable doubt. The unbroken chain of events laid down by the Court of Appeals leave us no other conclusion other than the petitioners' participation in the hazing. They took part into the hazing and together with their fellow fraternity officers and members, inflicted physical injuries to Villanueva as a requirement of his initiation. The physical injuries eventually told the body of the victim, which led to his death. Another young with the fact of hazing, the identity of the petitioners in their participation therein duly proven the moral certainty that procedure's conviction in an unprejudiced mind has been satisfied. The final note of hazing has been a phenomenon that has beleaguered the country's educational institutions and communities. News of young men beaten to death as part of fraternity's violent initiation rites, supposedly to seal fraternal bond, has sent disturbing waves to lawmakers. Hence, RA number 8 on June 7, 1995. Doubts on the effectiveness of the law. The court, however, scrutinized its provision and it is convinced that the law is rigorous in penalizing the crime of hazing.